Hello everyone, I hope all of you is doing well. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be sharing the views on the topic Access to Justice, Legal Aid and Lok Adalats. Let's start with the introduction. Access to justice is an essential component of a fair and equitable society, underpinning the concepts of democracy and rule of law. In India, marked by its vast variety and considerable socio-economic inequalities, it is essential to ensure that every person may seek legal remedies without any impediments. Legal assistance and Lok Adalat are fundamental instruments in this effort, designed to empower the unprivileged and protect their rights. Legal assistance is essential for supporting persons unable to afford legal services, whereas Lok Adalats provide an informal and efficient environment for conflict resolution, promoting peaceful solutions outside the traditional court system. These schemes demonstrate a dedication to justice for everyone irrespective of means, highlighting the deterrent effects of exorbitant litigation fees, complex processes, and protracted court delays on those seeking to assert their legal rights. India's access to justice system facilitates legal representation and promotes judicial participation and equity. Now let's discuss the meaning of access to justice. The notion of access to justice refers to people's ability to seek and obtain a fair legal procedure in civil, criminal and administrative matters. The procedure involves removing of financial, procedural and societal barriers that impede the persons from seeking remedy. The Supreme Court of India has emphasized the need of making justice not only available but also inexpensive, accessible and promptly delivered. In India, the Constitution guarantees access to justice, notably through Article 14, which ensures equality before the law, Article 21, which secures the right to life and personal liberty, also includes the fair and timely trials, and also Article 39A, that was introduced by 42nd Amendment Act of 1976, which mandates that the state provide free legal assistance to economically disadvantaged groups to ensure equitable access to justice. Notwithstanding these protections, obstacles such as illiteracy, poverty and procedural impediments impede many persons from obtaining access to justice. Consequently, the government established legal assistance programs as well as Lok Adalats to tackle these difficulties and provide inexpensive and accessible justice decisions. Now let's talk over history of legal aid services. The tradition of amicably settling disagreements is long standing in India, which is integral to its legal and cultural framework for generations. Conventional conflict resolution methods, including panchayats and community-based mediation, have existed for an extended period, demonstrating a robust commitment to restorative justice. Subsequent to independence, India institutionalized legal aid initiatives to provide justice for everyone, especially for the underprivileged. In 1958, the 14th Law Commission report emphasized equitable justice and pro bono legal assistance for the impoverished. Kerala initiated free legal help, setting a precedent for the country. Various groups were established to underscore the need for nationwide comprehensive legal assistance also. The 1972 Justice Krishna Iyer Committee presented its findings in 1973 that emphasized that the state's democratic obligation is to guarantee the legal system fostering social justice. The committee's recommendations endorse a robust foundation for future legal aid initiatives to provide justice to the underprivileged. Article 39A of the Indian Constitution mandates the provision of free legal assistance, asserting that economic or other impediments must not obstruct the attainment of justice. The 1987 Legal Services Authorities Act provides an institutional framework for legal help in India. This act transformed dispute resolution by establishing Lok Adalats for informal expedited settlements, which is outside the judicial settlements. This method alleviated the court congestion and enhanced the access to justice. Institutionalizing legal assistance and promoting alternative dispute resolution via Lok Adalats has enabled our country to establish justice as a basic right for everyone, irrespective of their socio-economic status. Now let's discuss about the act, that is Legal Services Authorities Act of 1987. The Legal Services Authorities Act 1987 is a crucial statute in India that is designed to guarantee the provision for free and proficient legal services to the marginalized segments of the society. This act was established in accordance with the constitutional directive of Article 39A, which mandates the state to guarantee that the justice is not withheld from any person owing to financial or other impediments. The act itself signifies a crucial advancement in ensuring equitable justice for all individuals, especially those from the underprivileged areas. The Act creates a systematic framework for legal assistance services nationwide by establishing many legal services bodies at various tiers. It seeks to eradicate obstacles that hinder these people from obtaining legal counsel and justice. The Act also establishes Lok Adalats, which function as an alternate dispute settlement method. These informal tribunals promote peaceful resolutions between conflicting parties and alleviate the congestion of cases in the conventional courts. Lok Adalats are structured to be more accessible and less formal than the conventional court processes, facilitating the expedited outcomes and fostering a culture of compromise rather than hostile litigation. The Legal Services Authorities Act was implemented on November 9, 1995 after a preparation period that facilitated the construction of essential infrastructure and frameworks in many states. The Act has undergone many amendments over the years to improve its efficacy and respond to evolving requirements in the provision of legal aid services. Main provisions of the 1987 Act. The primary provisions of this Act may be stated as follows. First is establishment of legal services authorities. The Act establishes a structured hierarchy of legal service authorities at national, state and district levels. The National Legal Services Authority, also known as NALSA, NALSA, operates at the national level, complemented by the state legal services authorities in each state and the district legal services authority in each district. The authorities are responsible for implementing legal assistance programs as well as ensuring access to justice. Now let's see what is the criteria for legal assistance, which is given in sections 12 and 13. Specific demographics qualify for complementary legal assistance as stipulated by the Act of 1987, which guarantees fair access to justice. An individual qualifies for legal assistance if they are member of one of the following groups. Number 1, individuals from scheduled castes or scheduled tribes. Number 2, victims of human trafficking or forced labor as outlined in Article 23 of the Constitution. Number 3, special protection is afforded to women and children. Number 4, individuals with disabilities, possesses the right to receive free legal assistance. Number 5, individuals with annual income below Rs 9,000 are eligible for legal assistance in the courts other than the Supreme Court, while those with incomes below 12,000 qualify for assistance if a lawsuit is filed before the Supreme Court. Lok Adalats. A significant aspect of the Act is the establishment of Lok Adalats, which are informal tribunals aimed at resolving disputes efficiently and amicably. The authorities are empowered to conduct Lok Adalats to resolve disputes through mutual agreement and to confer upon their awards the status of civil court orders as stipulated in section 19 to 22 of the Act. They possess the authority to educate compoundable matters, ensuring the prompt delivery of justice without the possibility of appeals. Now, how is the monitoring and evaluation is done? The 1987 Act designates the National Legal Services Authority as responsible for the monitoring and evaluation of legal aid programs in India. Periodic evaluations, data collection and feedback enables the NALSA to assess legal aid systems effectively. Program implementation is monitored in collaboration with State Legal Services Authority, District Legal Services Authority and Taluka Legal Services Committee. These authorities conduct conferences, training sessions and awareness campaigns to access and improve the legal aid services. Lok Adalats are overseen by NALSA to ensure case disposition rates as well as adherence to legal standards. Now, let's talk over the authorities. First is the National Legal Services Authority, that is under section 3. It is the primary entity tasked with executing legal aid initiatives across the India. It is responsible for coordinating legal aid activities and overseeing the organization of Lok Adalats at the national level. It provides standards and protocols for effective conflict settlement and ensures uniformity in the provision of legal help throughout the country. Next, structural composition. The central government designates these members. First is the Chief Justice of India serves as the patron-in-chief of NALSA. Second is an existing or retired Supreme Court Justice is appointed as the executive chairman. And third is the core team consists of more senior justices of the Supreme Court, legal experts, prominent lawyers and social workers. Now, let's come over to the functions. The primary function is coordination of legal help programs across the India. Next, implementation of policies that provide legal assistance to underprivileged groups within the society. Next, executing awareness activities and instructional programs for legal support. Then, overseeing the coordination of Lok Adalats on a nationwide level. Coming to the next authority, that is State Legal Services Authorities under section 6. According to section 6 of the Legal Services Authorities Act of 1987, state legal services authorities play a crucial role in providing legal assistance. According to section 6, this state legal services authorities must be created in each state to fulfill particular responsibilities and execute powers delegated to them. Now, what is the compositional structure? The SLSA is led by the Chief Justice of the High Court as patron-in-chief and an executive chairman who is either a current or retired High Court judge. The state legal services authorities are made up of varied set of members including judges, legal experts, social workers that ensures wide range of skills and opinions. Now, what are the functions? This organization oversees the operation of district and taluk legal services agencies and also coordinates state level Lok Adalats. They manage the scheduling of these Adalats, ensuring that they are carried out swiftly and successfully. In addition to it, state legal service authorities conduct awareness efforts to educate the public about the availability and advantages of Lok Adalats, advising district officials on how to organize the local sessions. They also have the authority over a variety of civil and compoundable criminal offences, allowing for expedited decisions. Now, let us come over to District Legal Services Authority, which is given under section 9 of the Act. Established by the Legal Services Authorities Act of 1987, the District Legal Services Authority is a crucial component of the legal assistance system. This statutory institution was created to implement legal aid programs at the district level, ensuring that everyone, particularly those from disadvantaged backgrounds, have access to the legal system. Now, let us talk about the compositional structure. Each DLSA is overseen by a district judge. The membership of the DLSA is diverse, including active advocates, social activists and judicial authorities, ensuring a broad spectrum of experts. Now, how is it working? The DLSA plans district legal initiatives and manages legal aid services effectively. Its main duty is to set up Lok Adalats for amicable conflict settlement, which deal with civil litigation, family issues and compensation claims. Pre-litigation conflicts are settled with the use of DLSA. The procedures such as permanent Lok Adalats, which are focused on the public utility services. Now, another committee we have is Taluk Legal Service Committee, given under section 11A of the Act. TLSC constitutes a significant component of the legal assistance framework established by the Legal Services Authorities Act of 1987. The TLSC operates at the grassroots level, significantly contributing to the organization of legal services and facilitating access to justice in rural areas and small towns. The TLSC is responsible for organizing Lok Adalats, enhancing public legal awareness, offering free legal assistance and advice to eligible individuals, and also coordinating activities with the District Legal Services Authority. Now, let us talk about the structural composition. A senior judicial official, typically senior civil judge or chief judicial magistrate, leads each TLSC and supervises the committee's activities. The committee includes legal experts and social workers knowledgeable about the local legal and social contexts, facilitating a comprehensive understanding of the community's needs. Now, how does this TLSC works? The primary function of the TLSC is to organize and manage Lok Adalats within the taluk. These informal courts serve as a venue for the prompt and peaceful resolution of minor civil and criminal issues. It ensures the availability of alternative conflict resolution processes for all by conducting Lok Adalats regularly, including in the rural areas. Now, after discussing about the authorities, let us talk upon about the concept of Lok Adalats. Lok Adalat denotes people's court. Indian history has a rich and extensive heritage in the use of alternative dispute resolution for the conflict resolution. Since antiquity, individuals have believed they could resolve their disputes independently, often seeking the intervention of panchayats to address the communal issues. The panchayat representatives use dialogue, mediation and adjudication to facilitate an agreement and enhance mutual understanding among the parties concerned. Lok Adalat was established based on the ideas of Gram Swaraj, advocated by Mahatma Gandhi, with the objective of advancing and implementing Article 39A of the Constitution, which seeks to provide equitable treatment and access to inexpensive legal assistance for all individuals. The Legal Services Authorities Act 1987 was established to fulfill the objectives of Article 39A and formally acknowledged Lok Adalats. Now, what is its need? The traditional judicial system in India is characterized by protracted timeliness, high cost, and a significant backlog of cases. Lok Adalats provide an efficient alternative for rapid dispute resolution while maintaining the integrity of justice. They offer casual, friendly, and no-cost method for resolving the disputes. Justice Ramaswamy emphasized the importance of Lok Adalats, noting that this dispute resolution mechanism not only conserves the time but also serves as cost-effective and efficient means of attaining mutually satisfactory settlements. Now, what are the primary advantages of Lok Adalats? It includes: number 1, reducing the strain on the judiciary. The Indian legal system encounters difficulties due to lack of judges and courts, resulting in significant case backlogs. Number 2, expedited case resolution. The Lok Adalat facilitates an increase in the number of resolved cases, thereby minimizing delays in the judicial process. Number 3, no court fees. Parties are exempted from paying the court fees, and any fees charged will be refunded upon the settlement. Number 4, simplified procedure. In contrast to regular courts, the absence of strict procedural and evidentiary laws enhances flexibility and accessibility in the process. Number 5, parties may engage in direct communication with the judge to articulate their concerns without the constraints of legal formalities. Number 6, final and binding decision. A case settled in a Lok Adalat is not subject to appeal, in contrast to the regular courts which allow for the appeals. Now, what is the statutory recognition? The Legal Services Authorities Act of 1987 conferred legal standing to the Lok Adalats in accordance with Article 39A of the Indian Constitution. The Act makes it simpler to create legal services authorities whose aim is to offer free and effective legal assistance to disadvantaged sections of society while promoting the fair and just access to justice. Furthermore, the Act authorizes legal services authorities to hold Lok Adalats regularly, ensuring that everyone obtains equal justice. Section 89 of the Code of Civil Procedure was enacted to encourage peaceful and consensual settlements between the parties while limiting the judicial intervention. The code also gives an option for settling disagreements via alternate ways for which ADR mechanism was designed, with the goal of settling disagreements between the parties without resorting to litigation. The prior provision focused primarily on arbitration and the processes described in the second schedule. Following the passage of the Arbitration Act of 1940, it was assumed that the law had been sufficiently consolidated, making Section 89 superfluous. It is critical to consider Section 96, subsection 3 of the CPC, which specifies that there should be no appeal from a decision issued by the court with the permission of the parties. A key result of the Lok Adalat's principal emphasis is the settlement or accommodation of the interested parties. If the parties are unable to reach at an agreement, the matter will be returned to the court or the parties will be urged to pursue the legal remedies. Now let's discuss about the jurisdiction of Lok Adalats. Lok Adalats have the jurisdiction to facilitate compromise or settlement between whom? The cases pending before the court or the matters that fall within the jurisdiction of courts but have not yet been filed. However, Lok Adalats do not have the jurisdiction over the cases related to non-compoundable offences under any law. Lok Adalats have powers equivalent to civil court as per the Code of Civil Procedure 1908 in the following matters. Number 1 is summoning and enforcing the attendance of witnesses and examining them under oath. Number 2, discovery and production of documents. Number 3, acceptance of evidence by affidavit. Number 4, requestioning public records, documents or certified copies from any court or office. And number 5, any other powers as prescribed by the law. Now let's come to the award. The award or decision which is passed by Lok Adalat is final, binding and has the same effect as that of court degree. No appeal can be made against its decision except in the cases where parties do not agree to a settlement, in which case they can pursue litigation in the regular court. Section 21 of Legal Services Authorities Act provides for the award of Lok Adalats. Section 21 subsection 1 states that Lok Adalat awards are presumed to be civil court decrees or other court orders. If the Lok Adalat reaches a compromise or settlement, the court fee will be reimbursed under the Court Fees Act 1870. Section 21 subsection 2 states that Lok Adalat awards are final and binding on all parties and cannot be appealed to any court. Now we have the list of case laws. Very important cases: the Husainara Khatun versus Home Secretary, State of Bihar. The case is famous for interpreting the right to a quick trial under Article 21. This court offered free legal aid services for those under trial. The case addressed prisoners' habeas corpus rights. It was found that Bihar's judicial system was terrifying. Many men, women and children spent years and years in jail awaiting the trial. It was revealed that many of these offenders were imprisoned for minor offences for up to 10 years since the trial was never started. The court ordered the immediate release of convicts and held without the trials of charges. In this scenario, free legal assistance for the needy and vulnerable is deemed essential for a fair and just approach. Whether a prisoner is guilty or innocent, the Constitution guarantees every person legal counsel. Additionally, Article 39A of our Constitution also promotes free legal assistance. Without the legal help, a person with economic or other limitations cannot get justice. To guarantee that everyone has access to courts, the Government of India and state governments must implement a crucial, powerful and comprehensive legal aid and legal services programs. Justice Bhagwati emphasized in para 107 of the judgment that the state must ensure speedy trials for all citizens and cannot use the excuse of insufficient financial resources to improve the administrative and judicial apparatus. Another noteworthy court case is Khatri versus State of Bihar, the Bhagalpur blindness case. The case began with multiple petitioners filing writ petitions at the Supreme Court under Article 32 to uphold their Article 21 rights. They stated that police officers blinded them in the station while detained. It stressed the constitutional need to provide legal aid to the impoverished and accused. The court stressed that state governments must offer free legal assistance to the poor under the Constitution. According to the court, the magistrate and judge must inform an accused about the option to hire a lawyer if it is clear that accused cannot afford legal services due to poverty or indigence. The court further held that the destitute accused's entitlement to free legal assistance is illusory until the trial judge notifies him. The court also emphasized that the Constitution requires an arrested individual to appear before the judicial judge within 24 hours after arrest, which must be meticulously enforced. That's about the Lok Adalats. Now let's come to the conclusion. Creating a just legal system in India requires that people must have access to justice via legal assistance and Lok Adalats. By providing free legal services and promoting alternative dispute resolutions, these organizations significantly contribute to the empowerment of marginalized populations. By facilitating quicker and easier conflict settlement, they also help to lessen the strain on traditional courts. Legal aid also ensures that those who face social or economic barriers may pursue justice without facing the financial difficulties. Lastly, by reinforcing the idea that everyone should have the fundamental right to justice, these actions create a society that is more inclusive and equitable. Thank you everyone for your time. It was a great pleasure explaining you about the concepts of Lok Adalats. We have discussed the entire concept in detail, and I hope that all the listeners have understood and enjoyed the discussion. Stay safe, stay healthy. God bless you all. Take care.